Almost always, after serving a federal prison sentence, you will serve a term of supervised release. Supervised release is a probationary period wherein you are monitored by a United States probation officer. The amount of time that you'll spend on supervision depends on the severity of the crime for which you were convicted. You can serve up to 1 year for a Class E felony or a misdemeanor, and up to 5 years for a Class A or Class B felony. Your judge will order terms and conditions of your supervision. These can include standard terms, such as don't violate the law, or special terms, such as attend a specified treatment program. And your every move will be scrutinized by your supervising officer. A violation of supervised release occurs when somebody under supervision either breaks the law or technically violates one of their terms or conditions of supervision. And the sentencing potential for any violation depends on the severity of the conduct. And the severity levels for a violation are broken down into the following classification. A grade A violation is conduct that is considered a violation of state, federal, or local law, punishable by over 1 year in prison, that is a crime of violence. That's a term of art in the federal system. A controlled substance offense, also a term of art in the federal system, or involves possession of a firearm or other destructive device, or any other violation of state, local, or federal law wherein you face a punishment of over 20 years in prison. A grade B violation is any other violation of state, local, or federal law punishable by a term of imprisonment exceeding 1 year. For a grade C violation, if your federal criminal defense lawyer can convince your supervising officer that the violation is minor and that not revoking you does not pose an undue risk to you or anyone in society, and that your violation is not part of a pattern or continuing behavior, then your violation may not be reported to the court. But grade A and grade B violations must be reported to the court, and you will face a supervised release revocation hearing. The consequence, the sentencing potential for any given violation, depends on the severity of the violation and your criminal history. Your supervised release revocation hearing will be in front of a federal district judge, and you can either contest the violation and present evidence and testimony on your behalf, or you can admit to the violation and present mitigating evidence in support of receiving a lesser sentence. There are a couple of key provisions of the United States Code that governs supervised release to keep in mind. First, under 18 U.S.C. 3583G, there are certain circumstances wherein a district judge has to revoke your supervision and sentence you to a term of imprisonment. Those include a possession of a controlled substance or an illegal possession of a firearm. But also, under 18 U.S.C. 3583E, if you've served over a year on federal supervised release and the interests of justice require it, your supervision can be terminated early. So, if you're close to having served 1 year and you've had no violations, you should contact a federal criminal defense lawyer who can file a motion on your behalf and argue it in front of the judge so that you no longer have to be monitored and supervised by United States probation.